I'm Drew Stevenson, and this is a video for my professional responsibility class about conflicts of interest and common representation or joint representation. We're talking about Model Rule 1.7 and specifically the comments 29 to 33 for that rule. And when we say common representation, we mean joint representation. You have agreed to represent two or more people who are co-plaintiffs in a lawsuit or co-defendants in a lawsuit or a criminal matter. It could be people who are going in together on a joint venture, want to start a business together, want to invest together in a parcel of commercial real estate, or they are co-owners of a business or real estate, and they want to you to represent them as they all sell it to some buyer. And so we talk about this with conflicts. Hopefully you remember this, that all sorts of things can go wrong as a representation proceeds. If it's litigation, they disagree about whether to settle or go to trial, or how much the settlement should be, how to divvy up the settlement amount. And the same thing can happen in a transactional matter where they disagree over time about what their share of either the profits and proceeds should be, or the control, who's going to get to make certain decisions. So let's proceed here. Comment 29. In considering whether to represent multiple clients in the same matter, a lawyer should be mindful that if the common representation fails because the potentially adverse interests cannot be reconciled, the result can be additional cost, embarrassment, and recrimination. So why additional cost? Well, they're going to have to all hire their separate lawyers to sort it out when things go wrong, and it's very expensive, right? It's not, in fact, it will probably be more expensive to try to fix this issue than if they had all had their own lawyer at the outset. It's going to be embarrassing for you and embarrassing for the clients. Recrimination means the blame game, right? So everybody blames everyone else when things go wrong, and they all can get together and blaming the lawyer, right? You shouldn't have represented us. This is your fault, and so forth. So do remember, we've talked about the things that can go wrong or break down between them, and if that happens, it's going to kind of be a nightmare for everyone involved, the clients and the lawyer. So ordinarily, a lawyer will be forced to withdraw from representing all of the clients if the common representation fails or falls apart. Now, of course, in some situations, the risk of failure is so great that multiple representation is plainly impossible. So you're going to have to make a judgment call as a lawyer. Should I do this at all? Or is this really likely to end up where these clients turn on each other or have a falling out? You shouldn't undertake the representation if it seems like there's a good chance you're going to have to withdraw, because that's very disruptive to the clients and to the court if it's a litigation matter, it's unfair to the other party if it's a transactional matter, and so on. And so here's an example that they give in the comments. A lawyer cannot undertake common representation of clients where contentious litigation or negotiations between them are imminent or contemplated. So if they're sitting in your conference room already like screaming and swearing at each other and saying, oh yeah, well, I'll see you in court, obviously you can't keep going with the joint representation, right? They're already at each other's throats. So you know it's already not working, and it's just going to get worse from there. So let's continue. Because the lawyer is required to be impartial between commonly represented clients, representation of multiple clients is improper when it is unlikely that impartiality can be maintained. So as an example, if one of these co-clients is a lifelong friend of yours, or a boyfriend or girlfriend, a relative or something, and so you have a little more loyalty to them, you know them better, than the others, and the others are kind of tag-alongs or people that were added in, well, now we have a problem, right? Because you, from the outset, are sort of favor one or like one more than the others, and the others are going to pick up on that or accuse you of that, even if you're trying to be fair. So if the relationship between the parties is already antagonistic, it is very unlikely that one lawyer can adequately serve all the client's interests. Here's some other relevant factors to keep in mind. Whether the lawyer subsequently will represent both parties on a continuing basis, and whether the situation involves creating or terminating a relationship between the parties. So it's a special risk if they're setting up a business or they come to you to dissolve a partnership. It's a special issue to worry about if you're hoping to continue representing each of these people separately on other legal matters, right? Because then you're going to have multiple layers of conflicts if at some point there's a dispute about this representation. And so if there's already a lot of tension or antagonism between them, it's imprudent for you to proceed with agree to do the representation. Now we're going to continue and talk about another issue in the next video about how joint representation messes up attorney-client privilege and the duty of confidentiality. But for now, that's our introduction of some of the problems, and at least when you should just walk away and say, you all need to get separate lawyers, I'm not doing it.